think you'll be able to hear her a lot.
There we go. I was waiting for that interruption. I can never hear a thing when somebody's talking and that thing goes off. So welcome, glad to have you. If you missed us the last time, we talked about just general risk management with vendors and ways to appropriately transfer the risk to them. This time we're focusing specifically on construction. If you missed us the last time and want the information, shoot me a note, shoot James a note. We're more than happy to send out that recording as well as the PowerPoint presentation. Also, Sarah is, I'm gonna overcommit Sarah. Sarah's available to help us walk through the process as well when that's needed. So as we talked about risk management and thinking about insurance policies, one thing we recognized was across our Citygate network, there seems to be a lot of misunderstanding and a lot of additional need for transferring risk that is not ours to somebody else. In this case, making sure that the contractor is actually providing some coverage and some coverages that for his work, and that you're not on the hook completely for a lot of those pieces. There are insurance parts to construction projects. There's the building part. It's called builder's risk. In general, we believe that it's best for you as the project owner or the property owner to own that builder's risk policy. We've seen a couple of situations where we had to switch contractors midway through the project. It could be the contractor went broke or the contractor just wasn't doing his job. And if the contractor has purchased that builder's risk policy, the policy goes with him because he is the owner. The other piece would be the general liability piece. There's a couple of different ways to handle it. There's kind of a low level, what's called an owner's and contractor's protective. It's a very just really basic, but it doesn't cover all the pieces. Then there's another step up. It's an owner's interest policy. And we'll happily walk through those pieces with you. The last part, which is actually not your responsibility, it would be the contractors, but you have to specify it in your job specs, and that would be for any bonds that you would want required. One key reason for bonds, if the contractor just cannot finish the project financially, then the bond company steps in and then has an arrangement with that contractor to make sure that the project gets finished. One of our guests here actually had a situation like that. The contractor who was digging a trench was unable to get through a boulder, and the mission had to rely on that bonding company to finish up the project. So a key part, not terribly expensive, but just a key part to specify. We've got a whole lot more. Sarah's going to kind of walk us through the non-insurance pieces. We're not asking you to spend more money. We're actually asking the contractor to step up and provide his part. Sarah's our risk manager. She works with the National Risk Control Group. She's part of 100 people. If there is ever expertise beyond her scope, she can loop somebody in to really any field or any detail that we need. Just a fantastic team to work with. Sarah, I'm going to let you take it from here.
Awesome. Thank you so much, John. And yes, like John mentioned, I am this senior risk control consultant. Excuse me. I work with both James and John, and really my role is to try and help you all both prevent claims and then mitigate the ones that do occur. So today's focus will be on a little bit on preventing construction related claims, but mostly on financing that risk, making sure that there's insurance to cover potential claims that could occur, and ideally transferring that risk to the at-fault party, which in this case could be a design professional, the general contractor or subcontractor that gets hired on the project. We do want this to be an open discussion, so if you guys do have any lessons learned from personal experiences, if you have any questions that come up, feel free to raise your hand or speak up, or even just put it in the chat. I should be able to monitor it, and I'm sure John and James will as well. Okay. Sorry, I'm just having some technical trouble. Need to get back to my presentation. Give me 1 second. Okay, good. I can change the slides now. So we did talk, today is going to be mostly about construction risk and insurance. And the reason why we have to hold a separate call for construction and building projects versus last month's call, which was on all vendors and third-party contractors in general, is because there are some very unique risks to construction projects compared to your everyday operations, but also the contractual risk transfer piece is very different because the contracts used predominantly in construction projects are very different than regular contracts that you may see every day. And most design professionals, so that could be an architect that you're working with or a fire sprinkler contractor who's going to design the fire protection systems if you're going to have fire sprinklers in a building, as well as general contractors, all typically use what is referred to as an AIA agreement. And AIA stands for the American Institute of Architects. And there's over 200 of these form AIA agreements. And they are all written by design professionals and by contractors for design professionals and for contractors. They did not write these standardized agreements for the benefit of the owner. And so that's why it's so important when entering into a construction agreement to make sure that you're working with attorneys as well as insurance brokers like John and James who are familiar with these types of agreements and can help you guys tailor these agreements, rework them, and make it so that it's equitable, fair for both parties, and ideally in your favor, and making sure that the people that you're hiring to do this work is taking on the risk for the job that they're performing, and of course financing it through insurance policies. And then before we jump into all that, I just want to do a quick recap for those who weren't able to be on the call last week, because I do tend to use insurance terms and jargon that maybe you guys don't use every day. So I want to make sure that we're all on the same page when we're talking about these. But the first one is indemnification. What indemnification means is that one party is going to accept responsibilities for losses that occur, and they are going to agree to pay for any damages arising from that loss that the other party may incur. So if a contractor agrees to indemnify you from a liability claim, if someone slips and falls on a project, it's the contractor's fault. They'll agree to cover the damages related to that claim. It's not going to fall on you. Another term for risk transfer is hold harmless. That's when one party releases another from liability. So in this case, if a contractor agrees to hold you harmless from a claim, they may agree to release your liability from it. And that way, of course, they're agreeing to accept it. They're releasing you from it. Also, potentially if their employees get hurt on the job, they're going to agree to release you from any potential liability, and of course would agree to cover that under their workers' compensation. And then the last key risk transfer term is a duty to defend. So the courts, as fun as they are, have decided that indemnification, hold harmless, and duty to defend are three separate things. If someone just indemnifies you, they only agree to cover damages. If they just hold you harmless, they agree to waive your liability. So you also need to have a duty to defend, which means they are going to agree to pay any defense-related expenses that you may incur if a lawsuit isn't filed against you. So all three are interrelated and connected, but are separate and distinct. So I did want to mention all three. Two other terms have to do with transferring claims to another party. That is subrogate and tender. Tender means you're going to transfer a claim to a person. Subrogate means that you are going to recover money you've already paid on a claim against a third party. So it both has to do with transferring risk. It's just one is transferring it on the front end. The other is recovering those costs on the back end. Another key insurance term is additional insured. Additional insured applies to liability policies. The named insured, or the person who's purchasing the policy, can add another entity onto the policy as an additional named insured. Doing so gives that additional insured rights under the third party's policy. That means you can file a claim directly with them. You can access the limits of coverage that they have, as well as the coverages that they have under that policy. So we always recommend that our clients get additional insured status whenever they're contracting with third parties and require them to obtain a liability policy. The next two terms have to do with the different types of policies there are. So the two main types in terms of claims are occurrence-based and claims-made. Occurrence-based means that the policy is going to cover any claims that occur during that policy period. So if the policy started January 1st of this year and ends on December 31st, the policy will cover any claim that happened in 2023. So if someone slipped and fell in 2023, that claim will be covered under that policy, whether the lawsuit is filed tomorrow or it's filed 2 years from now. Whereas a claims-made policy covers claims that are made during the policy period. So the policy that responds is the one that's in place when the lawsuit is filed. So even if the incident had happened a year, 2 years ago, if it's a claims-made policy, the current policy is going to cover it when the claim is made. And then finally, the last term I just want to go over is certificate of insurance. Certificate of insurance is a document that summarizes the different insurance policies as well as the different limits that an organization has. So it's a one-sheet piece of paper where you'll be able to see which coverages they have, what the policy numbers are, which insurance carriers they're placed with, and what limits they have. It's an extremely useful tool to have a summary snapshot of all the insurance coverages that the contractors you're working with may have in place. However, it is important to note that they are information only, meaning that they don't actually convey any coverages or any rights that you may have under the policy. So unfortunately, while they are helpful and they're best practice to collect and are good tools to have in your tool belt, what we really need to confirm that coverage is in place are the actual policy endorsements, because again, unfortunately, the certificate of insurance, while important, still does not provide any coverage. So now that we've gotten the boring insurance jargon portion of the presentation out of the way, we'll go ahead and jump right into the different risks and insurance that's needed to cover those risks during a construction project. Excuse me. So the first four I'm going to go over, we call them the core four because these are the key insurance policies that are going to protect the project itself, as well as protect claims that could arise from the project either during the project or after the project is completed. And the first one, which John mentioned earlier, is the builder's risk policy. So builder's risk is very unique insurance for construction because it covers the construction project itself, and not just when the building starts undergoing its renovations or the project actually gets started, but builder's risk covers the materials, the supplies, and any equipment on site, or materials and supplies that may be in transit. So, let's say you buy supplies to build a building and you've purchased it from the supplier and now it's in transit to your construction site. As soon as that purchase is made and those products are being delivered, they now become your responsibility. And builder's risk is going to cover that equipment, those materials, those supplies, as soon as you take ownership of it. So as soon as it starts moving in transit, maybe while it's being stored in a warehouse before the construction begins, maybe it's being stored on site. But this is really an all-encompassing policy that is going to protect that property. It also can protect soft costs, which are most often going to be potential income that you could have had the project finish on time, but now it isn't finishing on time because of a covered delay. Of course, insurance companies are for-profit companies. They do have exclusions, and oftentimes when a claim occurs, try not to provide coverage. So it does need to come from a covered cause of loss, but if there is a covered cause of loss, delays are caused, and you have some soft costs, and maybe you have additional interest on loans now, or you have some real estate taxes you incurred, but the project's not finished yet. Those are potential soft costs that could be covered under the builder's risk policy. And John had mentioned how it is a good idea to place your own builder's risk policy in case there's issues with the contractor. And the reason that comes up is because we often get asked who should place this builder's risk policy. Should it be the general contractor, or should it be us as the owners? And for the reasons John mentioned, we do recommend that you own your builder's risk policy, and that way you have continuity and you can rely upon the policy throughout the project and don't have any issues if you do have to switch contractors halfway through. Another piece of insurance that is important in any situation is going to be the general liability policy. From the moment you acquire a site, even if it's a vacant lot that has nothing built on it yet, you as a property owner now has premises liability, meaning that there's a reasonable expectation that that property is going to be in a safe condition and that there's going to be no hazardous conditions that could lead to third-party injury or property damage. I have seen some horror stories of vacant lots that get purchased. Organizations are slow moving to get that GL policy in place, and there might be an attractive nuisance hazard on the lot. So, for example, the claim I'm thinking of is there was an old rusty playground set that was on this lot. They didn't buy insurance just yet because they were planning on demolishing everything. And unfortunately, a minor did wander onto the lot and get hurt using the equipment. And there was liability for the owner because it was an attractive nuisance. The property did not have do not enter signs. It did not have security fencing. And unfortunately, it did cause a claim for that owner, even though they hadn't, started construction yet. So that is something to think about as you go through and you plan these projects. When you acquire these sites, we're going to talk about doing risk assessments for the sites, but you do want to make sure that you have your ducks in a row before you purchase this property. And that way you make sure that you have the right insurance in effect right away as soon as you would be accepting some of that liability. Another key insurance coverage for construction projects is pollution insurance. And I know that sounds kind of funky since when you think of pollution insurance, you're thinking about the graphic there on the slide, which is, emissions that are getting people sick. But there are quite a few incidents that could arise during construction projects that could be caused by what we call in the insurance industry a pollutant. Which is essentially anything which would not otherwise naturally be there. Some of the most famous examples are there was a elementary school where a teacher got sick because they were said that they were breathing in odors and that there was a dangerous environment. It caused them to develop occupational asthma. And it turned out that there was mold growing in the classroom. It was a brand new building. It was determined that the general contractor as well as the subcontractors allegedly created a dangerous environment that led to the mold growth. So even after the project was completed, everything was done. People had moved in, not people, but it had started being used as a school. Someone got sick from mold, the teacher, and it ended up being a successfully filed lawsuit, and the workers' compensation insurance carrier for the school was able to subrogate against the general contractor and the contractor for causing that dangerous condition. The reason why it's so important to have it is because most general liability insurance policies, and I shouldn't even say most, I should probably say all, exclude coverage for claims arising from pollutants. They even have specific coverage for claims arising from mold. So that's one example of something that could happen, which is why it's important. Another one that can be common is maybe a contractor is doing a renovation of an existing building. They don't know there's asbestos in there. Maybe you as the building owner doesn't even know there's asbestos in there. They're drilling holes in the wall to hang light fixtures, hang mirrors, and they accidentally drill into asbestos. And now there's asbestos airborne particles in the building, which could be an issue for people once it starts being used. But if the building is still going to be occupied, in other words, part of the building is still going to be used by you, your employees, the people you serve, while the other parts under renovations, the increased risk of potentially mold or asbestos affecting those building occupants is even more increased. And the last example I'll give is sometimes within construction projects, especially with brand new construction, a lot of soil gets moved around, and the soil erosion and runoff, there have been incidents where it'll contaminate a local creek or a local river during the development of buildings, and claims can be made saying that the contractor violated the Clean Water Act and state water statutes, and that can lead to a mess. And that is something that would be covered under pollution policy that would not be covered under a general liability policy. So even though at first glance it seems like, oh, well, we're not going to be using any hazardous substances, there's going to be no hazardous waste, there still is a pollution risk, and this is a standard insurance coverage. So if any contractor says that it's not, they may not be someone that you want to work with. And then finally, one of the most important insurance policies for a construction project is professional liability coverage. And we did talk about this during last month's presentation, but what a professional, or sometimes referred to as an errors and omissions policy, covers, which is different from a general liability policy, is that it'll cover claims that arise from a professional's advice. So if the architect has a design flaw, if the general contractor is giving you professional advice to do something and you following that advice led to a claim, the professional liability errors and omissions policy is what is going to respond. Those types of claims are excluded under most general liability policies. And because with construction projects, there is almost guaranteed going to be professional services being provided to you, you want to make sure those professionals carry this type of insurance so that there are no coverage gaps for claims that could potentially arise from the construction project. So other types of insurance that are important, which are important for any type of third party that you potentially could engage with into a contract. And we did talk about them last time, so I'll just run through them. But the first is commercial auto, making sure that anyone who is going to be working on the project, driving on the parking lots, driving materials, making sure that they have commercial auto insurance so that if they crash into the building, if they run over supplies, if they hit a pedestrian on your property, whatever it is, that we can guarantee, okay, this is going to be covered. It's not going to fall on our organization. Unfortunately, when these types of claims happen, people do tend to just look for the nearest building owner and then name them on a lawsuit. So chances are, if something is happening, you guys will be named in the lawsuit. And again, we just want to make sure that if these third parties are the ones that are causing these accidents to occur, that we know that they have coverage. So that's why, even though you don't own their vehicles, you don't have any interest in your vehicles, we still recommend requiring proof of commercial auto insurance. So we have comfort and peace of mind knowing that if they do cause a claim from that risk, that it'll be covered. And then the other one is, of course, workers' compensation and employer's liability. If a contractor or a subcontractor's employee gets hurt on the project, it should be covered by workers' compensation. Most states require employers to have workers' compensation to cover employee injuries. But if an employer does not have workers' compensation policy, it can fall back onto you as the owner. I unfortunately have a client in New York who had that exact thing happen to. They were doing a renovation project. They hired a sub to do some work, and it was the company was owned by a friend of theirs, so they had no insurance requirements. Turns out the friend did not have workers' comp. One of the people working for them fell off of the ladder, and it was a very severe claim, and it is now falling back on the property owner because the workers' compensation wasn't in place, and that owner still does have premises liability, and it created an avenue for a claim to be made against our clients. So even if it's a reputable company, even if you trust them, again, it's a state required insurance. Require it, get proof of insurance, and just make sure that it's there so that you're not having to accept the risk of someone else's employee injury exposure. And then the last piece of insurance I wanted to touch on is umbrella, or also known as excess liability. So for all the insurance policies that we require in a contract, we require the type of coverage, the coverage attributes such as additional insured status, and then we also require the limits. So a standard bare minimum, for example, a limit for general liability would be $1 million per occurrence. So for each claim that occurs, $1 million, and then $2 million aggregate. So for the entire policy period, $2 million will be paid out. That way, if one claim costs $500,000, we still have $1.5 million under that policy period to provide coverage. But unfortunately, juries have been awarding a lot of what we call nuclear verdicts lately, which means that they are awarding tens of millions of dollars, if not more, to plaintiffs. And it is just causing the cost of settlements and claims to rise. So we don't just recommend requiring the bare minimums of the primary insurance policies. We also recommend requiring umbrella and excess policies, just in case those primary policies get tapped out, and we can get additional coverage. I know ideally insurance carriers would say to require 10 million or more. That's not realistic for a lot of contractors and a lot of subs. The new minimum I've been seeing lately in terms of requirements is $5 million per occurrence and aggregate for the umbrella or excess liability policies. And you also want to make sure that any additional insured status that you have on those primary policies is going to translate to those umbrella policies. And that way, let's say you have the 2 million aggregate on the GL requirement plus the $5 million umbrella. Now you have $7 million of limits for that policy period that you would be able to tap into. So now that we've talked about the risks that can be covered, I did want to mention two main ones that typically are not worth insuring because of the cost, but I oftentimes see them required in both AIA agreements as well as lender and investor agreements. And I think that may just be because they're boilerplate agreements or just standard agreements that are written by attorneys who are not as familiar with the insurance marketplace and what's going on. So they're requiring something that just may not be needed and is cost prohibitive typically for projects. So the first one is earth movement or earthquake insurance. And John and James, if you want to jump in, feel free to, but this is typically a high premium with deductibles to 10 to 15% of the building value. And I see this required in states outside of California, outside of the West, where there really is very minimal earthquake exposure, if any. And again, it's just a cost prohibitive insurance that may not be necessary for your project. So if you do see this insurance requirement pop up in any construction agreements you're going to sign, make sure you reach out to James and John as well as your attorney to see if this can get negotiated out if it is cost prohibitive for you to do so. Another major one is flood risk. I see this a lot. However, most construction projects are not in a special flood hazard area that would need this type of coverage. Also, this type of coverage tends to come at an additional cost, and the cost usually not being commensurate with the risk. So if you're not in a special flood hazard area and you see this insurance requirement, again, make sure you reach out to James or John, whichever one is handling your insurance policy, so you can get the information you need to go back to the contractor, go back to the lenders and investors and explain how this is cost prohibitive and really not needed for your project. So now that we've covered the key insurance that we see on construction projects, before you begin development, it is, and like I've mentioned, the attorneys and the general contractors, it is important to make sure you're selecting the right professionals for your job. Selecting the right attorney is vitally important in that they really should have construction risk experience and also have a good grasp on how construction risk and insurance interact. Like I mentioned, most design professionals and contractors in the industry standard use the AIA forms. And again, there's over 200 of them. There are attorneys, they specialize in construction risk. So they're familiar with these forms, they're familiar with the provisions, and they know which ones are not owner friendly. So they can go through it and identify which ones need to be tailored, rearranged, what needs to be added in to make sure this is an equitable and fair agreement for both sides and not just in favor of the design professional or in favor of the contractor. And unfortunately, in my experience, if the attorneys don't have experience with construction risk or construction agreements, they're just not familiar with all of the nooks and crannies of these standardized agreements. And it can end up hurting you on the back end, and risk may not be allocated appropriately. So that's why I wanted to emphasize how important it is to make sure you get that attorney with the right experience. And of course, selecting the right general contractor is one of the most important things you can do. I always recommend asking people you trust for recommendations. Being able to get a good recommendation from someone on a general contractor is extremely important. Of course, you can look up reputable contractors on the internet. There's good, independent review sites where you can be able to read reviews from other people. And of course, you always have the option to go to and I recommend doing so, even if it's a recommendation from a trusted colleague, is that you check the Better Business Bureau as well as the state attorney general's office to make sure there's been no complaints made against the contractor. You want to make sure that their license is in good standing, that they have necessary permits to do the job. All of those things should just be standard and required during your general contractor selection process. You can also ask general contractors, during the bidding process, what insurance they carry. You can even ask for that certificate of insurance, get that summary of what they have. If what they have meets what you're going to require, great. If it doesn't, you can ask them ahead of time if they'd be willing to amend that. That may help weed out some of the contractors that you're deciding between. And then finally, you also want to make sure that you're looking, just like with the attorneys, you want to make sure you're looking for general contractors with experience with the type of project that you're going to be doing. Every project is unique. Every project has unique risks. I don't know if anyone on this call has ever dipped their toe into modular construction, but that's a good example I can think of where you don't, unfortunately, for general contractors without experience in that type of building, you don't want a contractor's first time doing modular construction to be on your project. There's just some extremely unique risks and issues that come up that you don't want to have to pay the price for if they aren't following best practices or industry standards. So now going through what we call the pre-development checklist. So this is, you found your attorney, you found your lender and investors, you found your GC, your design professionals, everything's good to go. But before you sign the agreements with any of these parties, it is important to do your due diligence because all these contracts you sign are going to be legally binding, and we want to make sure that they are working, the contracts are working for you, and also that you're going to be able to be in full compliance with the contract. So we mentioned site acquisition, whether it's a vacant lot or it's going to be an existing building, you want to make sure you're doing that site condition assessment risk. You want to understand if there's any environmental risks, potentially with the soil or anything that's on the property. You want to check to see if there's any special or unique hazards, and work with James and John and your insurance carriers to really understand the risk, what needs to be in place to protect it, both from the premises liability that you're going to have, as well as the risks you're going to have as you go through and you build the project. And you also want to make sure if it's going to be a renovation and they're still going to, the building's still going to be used, that is also a different set of risk. And you want to make sure that both your insurance agents as well as your underwriters know what that is before you enter into these agreements, because there may be additional coverages that you or they think a general contractor needs that you want to make sure it gets into those agreements. So again, before you sign anything, you want to make sure that you have a full understanding of the risk. And then if you do have lenders and investors, like I mentioned earlier, they use boilerplate agreements. They have a lot of requirements. Some make sense, some don't make sense at all. And I don't even know if some lenders fully understand what they're requiring. And it's important for you to remember that a lot of these provisions are negotiable. So you can negotiate these provisions to meet your needs. And a lot of times, you guys do great services for your communities. And a lot of times that's why these lenders or investors get on board. So it's important to remember that you guys are all on the same team and that we're not fighting with one another. We're really just trying to get requirements in that agreement that make sense for you and make sense for the project. And again, in my experience, if you explain to the lenders, investors why something may be needed or may not be needed, they are willing to work with you and make changes. The other two big agreements, of course, are going to be the design professionals agreement and the general contractors agreement. The best advice I can give is just never, ever, ever just sign the stock AIA form of agreement or any AIA agreement without having it reviewed by your attorney first. Again, they're written for the design professionals and contractors by the design professionals and contractors. And I've even seen some general contractors that send over an AIA form agreement to sign where they've actually edited it themselves and they've struck out any and all provisions that would give any protection to the owner to make it solely in their favor. Not all AIA forms are bad, some are equitable, but there are contractors and design professionals who try to even further make it so that it's in their favor. So you just want to make sure that you are not signing the first agreement that they send over, that it's always being reviewed by your attorney as well as James and John first, to make sure that risk is allocated appropriately to each party and that we have adequate requirements in place in terms of loss controls and insurance policies. And then once you sign the agreement, but before you start the project, you also want to make sure that you perform a compliance audit, because again, these are legally binding contracts, and if a loss occurs and it would have been covered by an insurance requirement that the lender had or the investor had, and had you had it in place and it didn't, you don't want to ever be in breach of agreement with the lender and investor. I'm sure that's not a surprise to anybody here, but you do want to make sure that you're in full compliance. So do a compliance audit in conjunction with your attorney and in conjunction with your insurance team. And then finally, before you begin work, you also want to verify that the general contractor and design professionals provide you with the certificate of insurance and the policy endorsements, so that you can not only confirm the coverage is in place with the correct limits, but also that you're an additional insured on those liability policies where you require it, that there's primary non-contributory wording, meaning that if they cause a loss, their insurance will be primary. Anything we carry will only come into play after those limits have been exhausted, that they waive their rights of subrogation. That way, if they do pay out a claim under the policy, we don't have to worry that their insurance carrier is going to come after us after the fact to recover those costs. You also want to make sure you have the notice of cancellation, so that if a contractor's policy is going to be canceled mid-project, that you have a 30 days advance notice. So that way you can be making sure that that general contractor gets another policy in place. And that notice of cancellation will come from the carrier. That way you have a guaranteed notification and you aren't caught up by surprise halfway through the project that your general contractor is no longer insured. And then finally, it is a best practice to have the contractors and design professionals insurance placed with the carrier that is financially stable. That way we know if a claim does occur, especially one that may be 7 figures, that the insurance carrier is going to be able to pay it out. The standard rating for insurance policies that we use is the AM Best rating. And you can require a minimum rating for the project, again, so that you have peace of mind that the carriers will be able to pay out claims. Some best practices for these types of contracts that we recommend is, if you're doing a lot of construction, it may be a good idea to own your own version of the A102 and A201, which are the AIA agreements most commonly used in construction projects. This is just to save time and future legal expense dollars. This way you only have to pay an attorney to write this agreement for you once, and then you can use it. It also provides risk consistency across all of your projects. If you're not doing a lot of construction projects, it's just on occasion, it may not be worth the time to pay an attorney to go through and do that versus just have an attorney review and edit these contracts as you go through different projects. But again, if you're doing a lot of construction, that's something that's good to consider. Another best practice is to make sure you're complying with your insurance carrier's loss control. They say recommendations. Insurance carriers are starting to, they might as well call those loss control requirements now, as well as your lender investor requirements. So your lenders investors may ensure certain types of coverages may be in place. Some may also require that certain loss control plans be in place. So like it says on the slide there, for example, really common ones are to require security plans, require hot work programs. So that's if any cutting or welding is going to be doing on the site, making sure that there's hot work permits being used, that there's a fire watch, that there's emergency response plans, and the like for construction projects, because there have been so many losses recently that are caused because security plans aren't being followed. One of my clients, they did not hire a reputable security company. The guard fell asleep on the job and an arsonist came and lit a project on fire that was almost 80% complete. It was a absolute catastrophic loss, but had a better security plan been in place, had there been compliance with that security plan, had there been auditing to make sure things were being done, that loss would have been prevented. So so if an insurance carrier is requiring a loss control be in place or recommending it, it is almost certainly coming from a loss that they paid out, and they did a root cause analysis and determined, you know what, this would have been prevented had this been in place. So if your insurance carrier or if your lender investor has any of those, you want to make sure that you are requiring your GC to do that within the written agreement. And then you also want to make sure you have a process in place to confirm compliance. So making sure you're getting those written plans before, or the programs before construction even starts, and then perhaps even having the project manager do some auditing to make sure that these things are being done. The last best practice we have here on the slide is to give your prime contractor candidates, let's say you've narrowed it down to 3 or 5, consider giving them these specifications ahead of time for bid equity. Let them know what the insurance requirements are, let them know what the loss control requirements are. And that way it's an even playing field for everyone. They know it's expected. If they don't think they can adhere to it, they may drop out on their own. But again, you can help create bid equity by giving everyone that ahead of time. So shifting gears a little bit in the contract, away from insurance to the actual risk transfer piece, specifically the contractual indemnification. So in construction, there's 3 main types of indemnification clauses. So type 1 protects the indemnity, that would be you, the owner, even if you're actively or passively negligent. So even if your negligence contributes to the loss, in this type 1 form, the contractor would still be required to indemnify you. Type 2 means that they will cover you if you were passively but not actively negligent. So if you had an omission or if you forgot to do something, that would be something that's passive, versus if you actively did something like, string a power cord across the walkway and cause someone to trip and fall, that would be actively negligent. Type 3 will only protect you from liability caused by the indemnitors, in this case, the design professional or the general contractor's conduct. So in other words, their negligent act or omissions will have to cause the loss to occur, whether actual or alleged, in order for them to indemnify you. Typically, we recommend the type 1 indemnification because it can be so hard to prove negligence. It may be after the claim is already resolved, the claim's been on your insurance policy, you've paid it out. Now we have to potentially subrogate. And it can be a years-long messy process, which is why we recommend type 3, because it's just a clean break. I'm sorry, why we recommend type 1, because it's a clean break. However, some states maintain special statutes that protect general contractors and subcontractors, and they only allow type 3 indemnification clauses to be in construction agreements. Again, another reason it's just vitally important to select the right attorney with construction experience, because they will know what's allowed under state law, and they will make sure that the indemnification clause being used in the agreement is going to be to the fullest extent permitted by law and grant you the greatest protection that's allowed. So those are 3 different types. And again, another reason why it's just so important to have an attorney review it and be on your side and advocating on your behalf. And then the slide also asks the question, does the liability insurance back the indemnity contained in your agreements? While they seem similar, being an additional insured under a contractor's general liability policy and being indemnified, they're layers of protection and they're related, but they're not the same. So the indemnification is what transfers the risk to them. The insurance is what transfers the financial risk and guarantees us it's going to be paid. So we not only have to have this indemnification in place to transfer risk to them for claims they cause, but we also need to make sure, again, that we're requiring that right liability insurance, that we're being named as an additional insured. That way we create layers of protection for ourselves, and we know, okay, not only is the risk going to them, but we know that they're going to have enough money to be able to cover the obligations that they agree to in the agreement. So up here on the slide right now.
Jump in real quick.
Yeah, go ahead.
I was just going to say, this is where that owner's interest policy really, where the work really comes in for the underwriter to make sure the contract, the contractor's liability policy, and the owner's interest all mesh to try to cover those gaps. The where the owners and contractors protective leaves a lot of those gaps untouched.
Awesome. Thank you, John. So this sample indemnification clause is that type 1 where they're going to be indemnifying you from any and all claims arising from the project. The language in purple are the key things to highlight. Again, we say to always put the to the fullest extent permitted by law, because the last thing we want is to accidentally have an indemnification clause that doesn't comply with state law. So for example, if you're in a state that only allows type 3, this would not be permitted. But by adding to the fullest extent permitted by law, we potentially can thwart a judge throwing out the entire thing, because we did make it very clear from the top this was only meant to be to the fullest extent permitted by law. We have seen claims where entire indemnification clauses are thrown out because they don't comply with state law. So that's why that one's in purple. And we already talked about defend, indemnify, and hold harmless. We do need all three in there just because they are three separate and distinct terms. Another key is that we want to make sure that the indemnification extends to claims that occur during the agreement or during when the project's going on, as well as after. Most states have a statute of limitations for liability claims. I've seen anywhere from 2 to 5 years. So if someone gets hurt, that's how long they have to file a lawsuit. If they're a minor, it's even longer. Sometimes they have 2 to 5 years after they turn the age 18. So we want to make sure this indemnification is going to cover not just claims that are made during the project, but claims that could potentially be made after. And same thing with the additional insured status on those liability policies. You want to make sure you're an additional insured for both ongoing and completed operations. There are certain endorsements that are only for ongoing operations. You want to make sure you get it for the completed operations as well. And then finally, you don't want any other provisions that could be snuck into the agreement to supersede the indemnification clause. So we do recommend adding in language that essentially states that if there are any conflicting clauses in the agreement, this is going to be the one that takes priority and applies. We've reviewed some of the common pitfalls last time, so I'll just quickly go over them. And we did just talk about them not holding up in court. The way your insurance requirements are worded is extremely important. Policy forms are changing all the time to try and reduce coverage for additional insureds. I saw in the chat, John mentioned we can send the slides out. We can also send a sample insurance specification sheet that will need to be tailored for every project, depending on the level of risk, especially the limits, and especially if your lender or investors are requiring certain limits. But we can at least get you the sample language for the additional insured status that you would be able to use to make sure that you're not going to fall into any of those coverage loopholes and potentially have an uncovered risk. And again, make sure you're requiring proof of insurance. And the last one is, especially in construction agreements, watch out for limitations of liability. Sometimes they'll try and limit the liability to the price of the construction agreement. They may try and limit their liability to the insurance limits that they have. They may try and limit liability to a different dollar amount. Again, another reason it's just so important to have the right attorney. They're going to know where to find those clauses, and they're going to make sure that the risk is allocated appropriately and that you are not going to have your risk transfer limited by an unfair provision in the agreement. There are some times where limitations of liability make sense and they are fair, and we'll talk about one a little bit in a little bit. But again, you just want to make sure your attorney is keeping an eye out for that, and that you're not going to get caught by surprise if a claim comes. Again, we will send out a sample insurance requirement clause that has all of these coverage attributes we mentioned earlier and are listed here on the slide. The only one we haven't talked about yet that I did want to mention is if any of those liability policies are on a claims made form, again, meaning the policy is going to cover when the claim is made, you can require that the contractors get an extended reporting period. And I say at least 2 years because that's usually the minimum number of times states give the statute of limitations for bodily injury. Please do adjust that. If your state's bodily injury statute of limitations is 4 years, you're going to want to make that extended reporting period for 4 years. Occurrence-based is always preferred and is standard for most general liability policies, but some policies for example, professional liability, it's more common to see them claims made. So for that particular insurance coverage, you want to make sure that you say, okay, listen, the coverage date starts the date this project starts, and we have until 2 to 4 years or however long statute of limitations is after the project's complete to report claims. And a quick note about subcontractors. So we talked a lot about transferring risk to general contractors, having design professionals accept risk. A lot of them will hire subcontractors to do work. And we want to make sure that the risk of the subcontractors is transferred to the general liability. To the general contractor. Now, you can require the general contractor to accept risk for subs in the agreement. That's something to talk to the attorney about. You can also require the general contractor to enter into written agreements with every subcontractor they hire, and you can set insurance specifications for insurance coverages and limits that the subs are required, and you can require the GC ensures that every sub is naming you as an additional insured, giving you the notice of cancellation, the waiver of subrogation, everything else we talked about. We want to make sure that flows down to every person working on this project so that you are not stuck with the risk. Now, the rest of the presentation is not going to be focused so much on insurance, but it does have to do with risk. I am going to quickly go through it because we are running short on time, but also because I am not an attorney. You know, nothing in here is legal advice. It's all just from an insurance and claims perspective. But I have seen some tough lessons learned from clients as well as just in the news that I wanted to pass along so that when you're talking to an attorney, either before you hire them to vet whether or not they have construction experience, or if you have an attorney that you work with a lot and you just need a checklist to make sure that you're going through some common items. This is what kind of this next section of the presentation is on. And what I wanted to mention is that some of the AIA agreements for architects has the architect's role as being the initial decision maker. And what that means is that they're the person identified in the agreement to render initial decisions on claims. So that you may have just contractually given them the right to choose who the defense counsel is, how claims are handled, you know, if a early settlement offer is going to be made. That's something you may want to consider striking. You may want that in your power, or you may want to leave that to the insurance carriers. But again, talk with your attorney because that is something that a lot of our clients I work with don't realize is in the agreement, and that they just gave that responsibility to a third party for a claim that be made against them. Another two has to do with specifically with disputes. So some have mediation as mandatory, others have arbitration, which is separate from mediation, as optional. So if mediation doesn't work out and you don't select a certain box, you may go straight to trial or litigation instead of going through the arbitration process first. So we call this alternative dispute resolution. That's where mediations and arbitrations fall under. Talk to your attorney, find out what they think the best alternative dispute resolutions are, and then especially the ones that are going to be most cost effective for you. So take the least amount of time, have the least amount of expense for you for those expensive legal fees, and make sure that your alternative dispute resolutions are in place in these agreements. And again, that they're going to be working for you, and they're what you and your attorney thinks best for your organization, just depending on the state that you're in. The next one I'm going to talk about is change orders. I always laugh when I see this picture. I saw it in a presentation, thought it was great, and stole it. So for those who maybe can't see the slide, the name of the big boat is called change order, and the name of the dinghy attached to the back of the boat is called the original contract. And really, it's just a comedic photo to show how expensive change orders can be for owners of building projects, and how much money there is to be made for the GCs. And change orders are addressed in these AIA contracts. And you want to make sure your attorney is adding in and emphasizing clauses that will help you reduce the cost of those change orders. So making sure, you understand what the markup percentage is, that you're getting supporting documentation for what the costs are. And again, going back to reading through your lender and investor agreements, I've seen lender investor agreements that require approval for change orders over a certain amount. So if your lender and investor is requiring that, you got to make sure your contract with the architect and the general contractor is also addressing that, so that if the lender needs approval, that you have the space within your agreement with the third parties to be able to do that. The next one I'm going to talk about is consequential damages. So as a quick recap, let's say this is an occupied building. Let's say this is a shelter, for example. Half of it is still being used as a shelter, half's under renovation. The GC screws up the pipe installation, and then the pipe breaks. Now, your actual damages are going to be the cost to fix the pipe. It's going to be the water mitigation. It's going to be damage to the supplies and potentially the building itself. Now, there could be consequential damages, which in this case may be, let's say that building's no longer inhabitable because of all of the water damage, and there needs to be additional demolition work now, and you're housing these people in the shelter, and now you need to relocate them. Who's going to be responsible for that cost? Now, actually all AIA agreements now have both the owner and the contractor waive consequential damages. The reason why is because of that Sands Hotel you're seeing there on the slide. And as you may be thinking, what the heck does a casino have to do with my project? But what ended up happening is, and I'll quickly go through the story again, knowing we're short on time, but there was a casino there originally. It was failing. A larger group bought it out. They were going to renovate it. They felt like they could make it more profitable because it was, too far away from kind of the main drag in Atlantic City, that they needed to have a flashier exterior, flashier signs that was going to get everyone to come into the casino, and they could start making a profit off of this casino that hadn't been profitable. They hire a general contractor to do work. The total cost of the project was around $16 million, but they paid the general contractor $600,000 for their consulting services. As they go through the project, there is a 4-month delay in the project of the Sands Casino. They end up suing the general contractor for, I believe it was, and don't quote me on this, I believe it was around $14.5 million. And again, the contractor was only paid $600,000. 4-month delay. The arbitrators ruled in favor of the Sands Casino. It then went through the court system all the way up to the New Jersey Supreme Court, who also ruled in favor of the Sands Casino. So this general contractor, who was only paid $600,000, had to pay out around $14.5 million to the Sands Casino for what they described as lost revenue because of the delay in the project. In response to this case, every AIA agreement was changed so that both the owner and the general contractor waive consequential damages. Now, in my experience, some contractors are willing to revise this to provide so that they waive it, but that the owners do not waive it. And the reason why is because, who's more likely to suffer damages because of the delay? The contractor's probably still going to be covered. They're still making a profit, but you may have some consequential damages. And that's why also earlier I mentioned sometimes it's okay to compromise and get a limit of liability. This may be one of those situations where you compromise and say, hey, you know what? We have people that we're serving. We really need protection if there's a delay or an issue with this construction project. We need to know you're going to cover us for these damages, but we will limit it maybe to the insurance policy limits, maybe to the price of the contract, whatever it is you agree on. But again, in conjunction with your attorney, but the key being that maybe it's okay to create a limit in that instance to get them to allow you to waive your right to claim consequential damages because it may be something that you need in your project. The next one I wanted to go really quick is just completion of work. So I know a lot of the contract we talked about pre-development, during construction, make sure everything's covered. But once the work is completed, you want to make sure that you still have some protections. A really common one that needs to be added into AIA agreements is to make sure that you have the right to do inspections before they issue a notice of completion, or that you have the right to put a punch list together to require them to do certain repairs or additional work before that notice of completion is issued. Anyone who's done a construction project, whether for their own personal home or for the organization, probably knows it's a lot easier to get the contractor to do the work before the notice of completion is done versus afterwards in working with the warranty team. So you want to make sure that this contract gives you that opportunity to look through the building before the notice of completion is issued, and that you can get repairs done before that's issued. Again, just to kind of light a fire under the contractor, make sure that it's getting done timely. And then there are other things with correction of work versus a warranty, as well as final payment options and conditions that you can add in. All of that's way above my head. That's always the reasons you pay attorneys to do what they do. But I did want to mention it because, again, it does pose some financial risk to you. I want to make sure that you guys are able to discuss that with your attorneys. And then this last slide, I'm not going to go over all of them. It's just a list of other clauses I've seen in construction contracts that have to do with risk that should be reviewed by an attorney, again, to make sure that it's equitable, fair, in your favor, and not just in the contractor or architect's favor. So you can kind of use this as well as the previous slides as somewhat of a checklist. It is not all inclusive. Again, I highly, highly, highly recommend working with an experienced attorney, especially one that's experienced in your state. They're going to be much better at pointing this stuff out, but these are some things that we have noticed that may be helpful for you to review with your attorney, or again, if you're vetting different attorneys, if they haven't heard of some of this stuff, maybe they don't have as much experience as they're telling you. And finally, I ended it last month. I may end every presentation I ever do in history with this, but do remember to document everything. ABCD, always be careful, document everything. Document your communications with the contractor, document your contracts with them. If there are any issues that you have that you see during construction, if you're auditing one of their, let's say one of their safety plans and it's not up to date, make sure that you have that all in writing with them, that you're documenting everything. It is so vitally important if a loss arises to have documentation so you can easily tender claims, so you can transfer risks, so that you make sure that the at-fault party is taking responsibility. Having solid documentation is going to be the best tool for your claim adjusters and for your defense attorneys to have to be able to make sure that you'll be in a defensible position if a claim is made, but also if you need to transfer risk, that you're in a position to be able to do so. And I know I just threw a lot at you guys through the fire hose, but I will pause there to see if there are any questions, and you can feel free to put them in the chat as well.
So yeah, feel free to take yourself off mute if you would like to just ask a question directly.
Okay. Well, if there are no questions, you can always reach out to John or James or myself afterwards. My email is there on the screen. Do copy James or John, whoever your producer is, if you do reach out, and we'd be happy to answer any specific questions. Again, though, just wanted to reiterate that nothing in here was legal advice. I'm sure I said it enough, but I do highly recommend the use of a construction risk attorney in this space. But we have seen quite a bit of construction related claims. So we do appreciate you guys taking the time to come and listen to this, so we can hopefully have a better understanding of different risks with construction projects, how we can ensure those, and again, how we can allocate risk appropriately to the people we're hiring to design and complete the project.
Thank you. So as you can see, it's a complex subject. James and I and Sarah are all finding communication early and often is better than after you start. After you start construction, a lot of times our hands are tied and we're unable to do much. You sign contracts, you may have signed away your rights, you may have signed away even your opportunity to have that liability covered by a contractor. So thank you for your time. Look forward to connecting with you. Next month, we will have another roundtable talking about risk transfer and with waivers and a whole bunch of other pieces. We'll send out email on that in a week or two. Thanks. Thank you for your time.
Thank you.
Thanks, John.
Thank you, guys.
All right, you're welcome.
John.